Welcome to the NCDWI Guy podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI Guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 171 of the NCDWI Guy podcast. On today's episode, I have criminal defense master Chris Fialko on the podcast. I met Chris down at the NCAJ convention in Charlotte, and Chris is just an amazing source of information and education in the arena of criminal defense. Chris has been doing this for 3+ decades and shares on today's episode just some amazing tips of how to conduct a great client consultation, how to prepare your case for trial, how to prepare your client for trial, why investigating at the scene of a crime is so important, as he talks about field trips, how to prepare your client for potential sentencing, just an amazing set of trial tips from Chris on today's episode. Chris also shares with us how he kind of built his criminal practice originally, which was more of a district court traffic ticket, DWI defense area early on in his practice before shifting to what Chris now focuses on, which is primarily white collar defense. And Chris describes how he built, again, that initial practice, as well as how he transitioned into more of the white collar arena. And both places, Chris shares with us how networking really played a part in the growth of his firm. And to that point, I'd like to invite you, before we get Chris rocking and rolling into today's conversation, I'd like to invite you again to the Freedom Fighter Summit in Asheville this October 19th and 20th. If you are thinking about building your firm through networking, this networking opportunity, which is designed for North Carolina criminal defense lawyers, is an absolute opportunity to take your game, to take your practice, to take your legal business to the next level. Please go and check that out. minnicklaw.com/summit to get more information on that front. As of the date of this recording, we are 90 days out from the Freedom Fighter Summit, and I am just super pumped about the speakers and attorneys that are going to be present at the summit this October. Don't miss out on fall season in Asheville, leaf season in Asheville. It's going to be an absolute blast, and I hope to see you there. Well, Chris, this is exciting because you're the first person that has been back on the podcast within like a 2-week period of time, because dummy me forgot to hit record when we did this originally a couple weeks back. I really appreciate this. This speaks to your character of forgiveness, coming back on after my idiot move. So very much appreciate you coming back on the podcast. First time for listeners, second time for me, but very excited to do this again with you.
I'm glad to be here. Let's hope it's not like a retrial, because you know how hard it is to win.
So. We're gonna go down some different veins, because that's just the way of the conversation. But really enjoyed the prior conversation. So between you and me, I learned a lot. So that was fun.
All right.
But yeah, just kind of diving into a little bit of background on your end. Kind of walk through what led you into law school, and then ultimately into the realm of criminal defense.
Yeah, so I went to law school mostly because I felt like I wasn't done learning yet. It's sort of a weird way to say it, but and then I went to UNC Chapel Hill Law because I wanted to live in a college town. The decisions you make when you're 23 years old.
Yeah.
So, I had been a sports writer at the college student newspaper and a sports editor and had some opportunities there, but I had just decided that it was a little bit of I'd seen a lot of professional sports writers in my travels for the college, and it seemed like a pretty lonely occupation. And so I'm more of a social dude. So the law school.
Did you go to Carolina for undergraduate as well then?
No, I went to Stanford University.
Oh, okay. Okay. So a good switch, change of scenery then.
Yeah, Stanford was phenomenally good place to go to school, but it's not a college town.
Yeah.
And so anyway, that's why I went to Chapel Hill. Plus, it's a great school, and I loved living in Chapel Hill. So that was good.
Yeah, Chapel Hill is really cool spot. I've only been there a couple of times, but it's just, I mean, it's gorgeous. I mean, what a beautiful campus they have down there. I mean, just a cool spot. Well, did you have any thoughts of going into like entertainment or sports law as you were kind of going through that background?
I was, again, I sort of just had like an open mind about it. But I did, that was sort of what I was thinking is, because I had also worked at the student radio station. I was a big music fan, so I thought I might try to do entertainment law or First Amendment law or so forth. But then what happened was that, and it's funny how sometimes you get lucky. I was taking a class from Richard Rosen, who was, a very well-known criminal law professor, and we had our first midterm in our first year, first test, right? And you're in this room with like 80 other students, and he did a fact pattern on the test using name. It was about a group of people who were robbing a bank and then fled from it, and I think there was a shootout, and there were all these issues that you had to spot in it. But he had used like the names of Eric and Clapton and Derek from Derek and the Dominoes and Layla. And I'm not sure everybody in the room recognized that. And maybe the younger generation won't recognize it, but that, was a very famous song, and I recognized it. And I got right in the flow and started writing. And then I realized that like I had been training for this as a sports writer for 3 or 4 years in college, which is, writing under deadline after you see something and trying to relate it and figure it out and write it out. And so I remember being in the room and thinking, I can do this, man. I know how to write. I know how to think fast, and I don't mind the deadline pressure because I had done it many times, especially covering the Stanford basketball team where, a game might end at 9:30 at night and I had to file my story by 10:30. And so I really enjoyed it, and I started incorporating some Latin lyrics in my essay and so forth. And that just fired my interest in it. And I remember right afterwards, a bunch of my fellow students totally stressed out, and they were like, "That was really hard." And I was like, "I love that. That was great."
That they hated your guts.
So after that, that's what piqued my interest in the criminal law. And then, how I got into it eventually was that after law school, I took a job at a small firm in Charlotte, and it was I think it had 4 or 5 lawyers at the time, and that did lots of civil litigation, but they gave me all their quote unquote criminal shit, from speeding tickets to DWIs or whatever that local businessmen got in trouble because they represented a lot of local businessmen. And then I was in court over there, and I really liked that, right? I liked trying cases, even in misdemeanor district court. Most of it was misdemeanors. I liked the social aspect of it. And so after 2 years of doing that, I set up my own shingle and just tried to do 100% criminal. So that's how that worked.
Yeah, I mean, there's a couple of things there that I think are cool and just question about in terms of, the prep work of being in that kind of writing mindset prior to going into law school. That's one of those things that, again, when you go in, maybe you're not thinking that that's some big advantage, but huge advantage in terms of having that, kind of long draft format that's under pressure, under deadline. I mean, that's just such a huge part of the law school process. My undergraduate, it was very intensive reading. There was a good amount of essays and papers as well, but a lot of reading. And so, that was one of those things that going into it, it wasn't like you don't know that that's necessarily going to be something that's helpful, but that volume of reading and writing and timeframes and basically having too much assigned and not enough time to get it done, and kind of being in that where's the priority, I gotta submit something within this expected time frame. I think that's a huge leg up in terms of like those relationships that you had where you were getting cases in district court. That's something that I feel like a lot of new lawyers, would really benefit from, but is actually a difficult thing to build like straight out of law school. So what did that kind of process look like in terms of building that networking?
Well, let me back up and say, like, I think you're asking about how did I get the work, but you were talking about building relationships too. The other thing is that, in criminal court, you're there in court and you have to build relationships with the DAs and the court bailiffs and the policemen and the judges. So maybe we'll loop back around to that. But so what I did was I sat down and I said, I'm going to go to lunch with somebody every week for 52 weeks. This was in 1994, I think.
Where did that come from? What was the inspiration of that?
I'm not sure, other than I've never been afraid of asking people questions, like, and interacting with them. That's something you do in sports writing a lot too, right? You're asking questions. So I don't know, but I really don't know where it came from, but I sat down and did it, and I didn't limit myself to just talking to the other criminal defense lawyers in town. So like I went out with a couple of the court bailiffs and probation officer, and basically I was just like, and sometimes we were all not of means at that time, so we were actually bag lunching together and so forth sometimes. But I just would ask them questions, and then I would say, this is what I'm trying to do. Do you have any suggestions for me? And the other thing I learned is that everybody said yes, right? Like
that's awesome.
Like nobody ever said, "Who the hell are you, Fialko? And why should I have lunch with you?" Like they were all like, "Yeah." Everybody. I had even some of the judges. So that's what I really encourage young lawyers to do is to meet with people. I do remember reading a book called Hardball by Chris Matthews, who was for a long time on, political talking head on TV. But one of the things I learned in there, he said, was that if you ask somebody for a favor, they sort of become loyal to you, which is counterintuitive, but it works. And so by asking people to go to lunch, I was asking them for their time or their favor. But after that, I think they just felt like, okay, somehow they were like, oh yeah, this guy thinks I'm important enough to ask to lunch. So, I'm going to send him some work or be a little loyal to him. I would encourage people to read that book, not just for the politics, but for the sort of the social networking parts of it. So
yeah, so that's awesome. But hopefully me asking you to do the podcast twice will have
That's right. I'll be super loyal.
No, I think that's such a cool point. I mean, I think one of, the same reason why a lot of lawyers, struggle early on in practice trying cases. You just don't want to look silly in front of a judge, in front of whoever's sitting in the gallery, in front of your client, the DA, like that same fear. I think it also is the same thing that's like, man, there's this lawyer that's been practicing for 10 years, 20 years, 30 years, I don't think I should approach them, when in reality, it's like, that's definitely the person that you should be approaching, is that person that's been doing it for a long time. And, particularly in the criminal defense bar, I feel like, as you were kind of talking about, nobody's really saying no. I've never had somebody that's just like, man, I don't feel comfortable,
Right.
meeting with you, or so, something along those lines. They might be really busy and not get back, but at the same time, like, there's no harm in asking. So I love the mindset of not just like, I'm gonna meet with some people for lunch and try to build relationships, but being very methodical about, I'm going to do this every week for a year straight. And, then we'll see what happens. I love that.
But the other thing is I still do it now. Like,
Yeah.
so
Yeah.
almost every week. Now I'm going with people I already know and so forth, but I also try to still do it with people I don't know. I think it goes back to, I always learn something from every meeting I have, so it helps to do this job, to be a criminal defense lawyer, to be a learner. Like, you always want to learn about stuff. You were saying though about the fear. What you're talking about is a fear of rejection, right?
Yes.
You
for
ask
sure.
somebody and they say no. And also the fear of losing. You can't really have that if you're going to be a good criminal defense lawyer, because we lose most of the time. I will tell you this old war story though, which I was lucky back in the mid 90s that there were just lots of trials we had in district court, and much of the time it was in an empty courtroom, right at the end of the docket when there's only a couple of people around. And so I was able to screw things up or not do as well, and not feel as much rejection or as much of an audience. But the other thing was that I think that back then the judges were more interested in giving constructive criticism to the lawyers, because at least the model in Mecklenburg, and it's still the model, is that almost all the assistant DAs in misdemeanor court are right out of law school, right? And so the judge is trying to help them do better, and I was right out of law school too. So we actually had on Thursday and Friday afternoons, and a number of my classmates from law school were the assistant DAs. And there were times where we would ask the judge at the end of the docket, look, this might normally be a plea, but the courtroom's empty. Let's try this case. We were basically telling them, don't give a trial penalty. Just let us try the case and learn. And Judge Scarborough especially used to do that. So
that is awesome. I mean, that's such a cool mindset. I mean, I think, when you're first again trying cases, it takes a lot of courage to just get up there and throw something up in front of the court, first of all, because again, you don't want to look silly, but then, avoiding any like negative feedback almost seems like the best way to protect yourself. And after, a couple of years into it, of just being like,
right.
kind of made it through another one. I think that another lawyer had basically said, I always, go up and ask the judge, the jury, what did you think? What could I have done better? And so I started doing that. And, the more that I would try to kind of like couch it in terms of, if you had tried this from, my perspective, what would you have done differently?
Right.
Trying to almost like give the judge permission to criticize, as opposed to like feeling like, I don't want to really like hurt this guy's feelings or something like that. But the more I tried to like couch it in terms of like, throw it on me, I want to know how I can improve. I got some really good feedback points from both jurors and judges. So that was I think a great way to improve is just to ask for feedback, and from the DA as well. I'd ask the DA, what would you have done differently if you're on my side of the table?
I remember also back then, on my yellow legal pad at the back of it, right? So like at the very last page, I would take notes about what other lawyers were doing throughout the week. And, I was trying to say, okay, well, like this lawyer, like Eben Rawls was a fantastic lawyer back then that I learned a lot from. He seems to do things this way, but that lawyer, Theo Nixon, is much more blunt. He does it that way.
Yeah.
And I was like, which one should I I was always trying to learn the skills from the people, and I was sort of methodical about writing it down and going back and looking at it. So that's a small thing I'd encourage young lawyers to do. The main thing, I know we're skipping ahead maybe on your outline, but when you're in court and you're a young lawyer, put this damn thing away. In the 90s, like we didn't have any phones, or the phones we did have were these little block phones that barely worked. And so when you were in court and waiting for your case, there was nothing to do mostly but watch and learn what was happening in the courtroom. And now, when I go over there, I see lots of lawyers, young and old, while they're waiting, they're just looking at their phone and not learning about, the proclivities of this judge or this DA or even that witness. Because as you know, in district court, you see the same police testify over and over. So,
yeah. And I think, again, that's such a great opportunity to have a conversation with another lawyer in the courtroom. Again, it's, the one barrier to entry in terms of like going out to lunch with somebody or, getting somebody to pick up the phone is time. And so when you're stuck in court and there's an amazing lawyer sitting next to you that's also stuck in court, it's like you use that as the opportunity to have a conversation, as long as you're not getting a nasty look from the judge or bailiff to shut up, like this. You got to be careful on that front, but it's a great opportunity to learn and just say, hey, look, can I pick your brain for a second about this case that I have? It's amazing how many like good angles that I've gotten from, a 10-minute conversation with, one of the local experts here on a DWI issue, whatever it might be. I mean, there's just been so much good feedback. And when you're sitting there looking at your phone, you're missing that opportunity to have a great conversation with another lawyer. Yeah,
exactly.
Well, Chris, I'd love for you to kind of walk us through, because this was one of the coolest things that I felt about our conversation a couple weeks back, was kind of your process when you get a new client, kind of your initial conversation with them and, kind of how you're proceeding through the case kind of in the early stages. So, when you get a phone call, from a potential client, what's your process then?
So it's sort of evolved over time. So I'll talk about it, what it is now. But the number one thing is that I try not to do consults over the phone. I try to do them all in person, because I think you can just learn a lot more and the person will be much more forthcoming as well. And the other thing is I make sure that I meet with this potential client one-on-one. So not with their spouse or their mama or their son or whoever in the room with them, maybe, because first of all, if they're in the room, then the attorney-client privilege doesn't attach, which is basic. But secondly, they're definitely more forthcoming and willing to share things and tell me the good, the bad, and the ugly about the case. So that's sort of my number one thing. Now I used to just say start asking lots of questions, but now I just have this phrase I've developed, which is I sit down in front of somebody and I say, pick a natural starting point and tell me what happened. And what that really I found does is I learn what they think is most important about their case, like right away. Whereas if I sort of direct it from the beginning, it might not come out that quickly. And then the other thing is that I think over the years that I've become, like I grew up a Yankee in Connecticut, and I sort of have a bluntness about me that I, for a long time, tried to temper, right? Because I was down here. And now I'm a little bit more blunt. So if a client is, I think, not really telling me what's happened, I'm more blunt with them and say, look, if you want me to help you, I've got to understand everything about this.
Yes.
And some clients, will talk freely and do a good narrative. Other ones, you sort of have ADHD, and so you have to interrupt and hem them in and say, wait, we're getting off track. So it depends on the client. And the number one skill I've learned now for the first client meeting is listening. And they never taught us that in law school. ever, right?
Yeah, for sure. No,
Like
not at all.
you go to law school and you do moot court and you learn all these skills about how to talk yourself, right? But, and which is important in our job, but really sort of learning the skills of listening. So there are times when I just don't take any notes because the notes can distract me, and I just sit there and try to listen hard. It's, we should all be training ourselves on being better listener.
Yeah, I love that. There's so much there to unpack. I think, first of all, in terms of the in-person meeting, obviously this somewhat depends on the type of charge that's, being charged, speeding ticket versus, somebody facing a murder charge. I mean, there's a different level of like connection that is required. But I will say to that point, I think that there is a massive advantage in terms of separating yourself from other lawyers when you have an in-person meeting with a client. The everybody can feel that level of connection when they're in the presence of another human being. There's just, I mean, it's something that you can't replicate with a Zoom call. You can't replicate it with a phone call. Certainly a text message is not, I mean, not the same thing. And so I think, you give yourself a much higher competitive advantage in terms of the trust factor, the ability to speak openly when you're talking with somebody in person. So again, obviously it depends on you got somebody that's calling in on a DWI case that lives in California. Okay, in-person meeting's not going to be possible, but at the same time, like that's, I think the convenience factor, even on the lawyer's end of things, to do phone calls has really kind of steered things away, I would say, from in-person meetings. And that's something that you just can't replicate that, and so I guess to that point, I would encourage people to try to figure out a way potentially of making that happen. But then, if you can't, and you get your first opportunity to meet your actual client in the courtroom or wherever it might be, make sure that you're going out of your way to have like a conversation with your client in person at whatever opportunity that first meeting is, because it's just such a huge differentiator in terms of the trust factor. And and I'm guilty of this myself, so I'm kind of not speaking of this as something I do every time, but there's so many times when you have that break before court gets going or whatnot, where you could be, again, sitting down for 10 minutes in the gallery with your client. And instead, like you were just mentioning, you're up there in the front row looking at your phone, doing nothing. And so, don't waste that opportunity. I mean, that really helps the client, if that's the first meeting, helps the client feel comfortable about what's about to happen in court. The other thing then, we kind of went down this hole the last time we spoke, but in terms of getting your client alone, just hugely helpful. I mean, it's one of those things where, when you have a spouse, a parent, a significant other, whoever it might be that's in the room, you're not going to tell the whole truth, because you probably not told that person the whole truth to begin with. And so you're locked into whatever your story is if that person is in the room. And I know that you had mentioned you've kind of gotten some people where it's like parents are footing the bill, maybe spouse is involved in the financial investment, wants to be a part of the conversation. And so they're like, well, we're not comfortable if this is the way things are going. And you got to be okay with that. If that's kind of the way that they want to go, you got to be okay with that.
Yeah. I mean, I will tell people, if they come in with family or even a close friend, I'll say, look, we'll have 3 meetings in the next hour. We'll have this 1-minute meeting we're having right now with you and your family, where I tell them I'm kicking you out, and then we'll have the meeting with me and the potential client, and then I'll bring you back in. I'll tell the family I'll bring you back in after that meeting, and I'll tell you in general what I think. And that seems to work sometimes, but you really do have to establish the relationship with the client one-on-one, especially, I do more complex cases than I used to, and fewer of them that are going to take a lot of time with the client. So there's a couple other advantages though too, like doing it in person. I get to know whether I think actually I'm going to be able to interact well with this client, right? If I spend the time with them, they're yeah, I can cuss, right? You said that's
Yeah,
allowed.
yeah,
So,
yes.
yeah, so like what Dave Rudolph, who I was partners with forever, the best lawyer I've ever worked with, he called it an asshole premium, right? So
Yeah,
meeting with the client, and afterwards, he and I would be like, "What should we charge this guy?" And Dave would say, "Yeah, I mean, this one's gonna be a total pain, and it's gonna take a lot longer." And so I do charge that premium and quote it sometimes, and almost always people pay it anyway.
yeah.
Um,
The
but
the go away fee.
the other thing that I've changed over the years is that I hardly ever quote a fee at that meeting. Like I tell
Yeah.
people, I'm going to think about this, and tomorrow morning I'm going to call you back and tell you what the attorney fee will be. That surprises people sometimes. And I didn't, I didn't used to do that because you want to convert the client right there, but I do so many fewer cases. And I really do want to make sure I'm charging a fee that is both fair, but also allows me to do the work. And so I do that most of the time now.
Yeah, that's definitely something that I think is very out of the ordinary, and obviously maybe with more complex cases. But I think what that communicates to the client is, that you're looking at their case from a very like individual perspective.
Right.
They're not this is not a cookie cutter situation. This is not a one size fits all. Like I'm really here to go to bat for you individually. So I think that is such a powerful, again, obviously it's probably helpful on your end, as you were just saying, to figure out what a reasonable fee is for this particular situation. But I think from the client's perspective too, it's kind of like, I've gotten all this information, Mr. Fialko has sat down and kind of talked about everything with me. He's given me the legal, synopsis of kind of what we're facing. And he's going to go back and think about this some more before he even decides if this is a case he should get involved. I think I think that really does impact the trust level that the client's feeling coming out of that.
Yeah, I hope so. I mean, but it seems to work for me so far. So see if it keeps on going on. It has been different though since the pandemic. So many people just want to meet by video, and so I am doing that sometimes now. And it's much better than a phone call, but it's still not the same as being in the room. And I'm also never quite sure who's off camera listening if I do a video conversation, right? So, is the person really feeling like they can be forthright is another problem.
Yeah, no, I mean, 100%. I guess in terms of like your preparation, then from the time that you onboard a new client through kind of like, trial plea, what does your prep look like as you're kind of working through discovery, follow up with client, preparation for trial? What does that look like?
Well, so there's sort of like two things. One is I have this theory that I've developed of sort of over informing the client. So like I give them lots of updates. I give them copies of the statutes. In federal court, you have to give them copies of the sentencing guidelines, even when you're in trial prep, because you have to understand what the worst case scenario is and so forth. So I'm just really giving a lot of stuff to the client because I found that an informed client then gets more engaged in helping me understand their cases. So that's one theory I have. Preparation, I always start with the pattern jury instructions, which spell out the elements of the crime that the state or the federal government is going to have to prove. And it seems really basic, but I'm sort of adamant about that. Like the first thing my paralegal does when she opens up the file is to print all the charges, the statute and the pattern jury instructions. And that's the one physical thing that goes in my file now. We have everything electronically, but I want to sit down and read that again so I can always be thinking, this is what they have to prove. Can they prove it? So that's really where, and then I have a checklist, of a whole bunch of other stuff that we do. I think I mentioned it before. There's this really good book called The Checklist Manifesto by
Which I said I needed to read after I failed to
right.
hit the record button the last time. Get that checklist
That's
going
right.
for podcast.
Number one on the checklist. Press record. It's by an author. His name is Atul Gawande, who I went to college with and knew just a little bit at the newspaper. A great writer. But I would encourage you to. It's not about law. It's mostly about construction or airline pilots or so forth. But it talks about how having checklists that make you go back to the basics not only makes you do things, but it can help you be more creative, because you're going back always. It sort of gives you the structure and from there you can make up ideas. And I'm constantly updating my checklist. Um, and I've had to tell my staff that, like, if I tell you to do something and it's not on the checklist, put it on the fucking checklist. Because that means that I've thought of something that I hadn't thought of before, and I might not think of it in the next case unless we get it in there. Um, so I really that's what I do, and then timelines are really important in any case, big or small. What happened, when, in time, because it helps you explain the context of things. Something that can look really bad if you just have the one page or even the one 30 seconds of video. If you step back and you see what happened before and after it, or learn that, then it can really mitigate or completely flip the meaning of things. So I have a program called Case Map I use, but other lawyers use different timeline stuff. So I encourage everybody to do that. And what we do is we shove that all of the discovery into the timeline as we get it, and then you can hit sort by time, and then you go back and read it that way, and then you're all of a sudden like, oh, this guy said this then, but only after he had met with another guy who told him what to say. So there's lots of things you can learn in that path.
Yeah, I love that. Yeah, a couple of thoughts on everything that you just said. I think one of the things that's so helpful, that kind of I've learned over the years is to try to give the client the kind of worst possible outcome, or maybe worst expected possible outcome as early as possible, and not sugarcoat anything. I think I used to do a little bit more sugarcoating. I think on the flip side of that, you can go down like this, fear mongering path of like, you're looking at, a 36-month potential DWI sentence, and it's a level 5. It's like, that person's not going to jail for 36 months, there's like the opposite end of things. But I do think that, when you have a client that realistically is looking at active time, if they're convicted by plea or by trial, like getting that info into their hands as early as possible and kind of ripping the Band-Aid off, you're arming your client with the ability to start preparing for that, whatever that looks like, getting, their house papers, bank accounts, all those things in order. It's a big thing that might be coming down the pike. And I think having an open conversation as early as possible is huge on that front. And then to kind of echo the checklist end of things, I think this is something that you see, the DAs, United States attorneys, they do this very well. Like there is a checklist, question, and it sometimes can be boring, and it can be one of these things where it's like, oh my gosh, we're going through this if I hear this laundry list of HGN questions again, I'm going to like just you see the judge's eyes rolling back, they're losing the jury, like it's just like this is really going down the rabbit hole here, but it's for a reason. It's like you want to make sure you're not missing venue, jurisdiction, elements of the charge, how am I proving impairment? I mean, that's what those checklists are designed for. And like you said, when you have that checklist as a starting point, you are, I would say, potentially more likely to start off boring, but you're not missing anything. And then as you get more and more familiar with your case, whether that's preparation or, cross-examination in the courtroom, and you have your checklist questions, then you can get inventive and creative with it, knowing that you're not going to miss anything. You don't have to always be referencing the checklist. So I mean, I think that is such a huge benefit and value to having that organization.
One thing I learned about, especially, when I was trying many DWI cases, and other bench trials and misdemeanor courts, was that even though you might have an outline of or a checklist or an outline of your cross examinations, don't start at the beginning, right? Like, I often realized as things went on that I might have like 25 topics or even 3 or 4 topics in a smaller case that I want to get to. It doesn't mean I have to do it in the order that the prosecutor did it. And in fact, much of the time, it's much more effective to jump right into a particular spot where the witness is most vulnerable or you have the best shot. You can always double back and say, okay, let's go back to when you first turned on the blue lights now, you're right. But it doesn't, you shouldn't be a slave to starting there.
Yeah.
You can fall into the trap of just getting the witness to repeat his testimony that he already gave. So nowadays, like, I have this outline of a cross-examination, and I'm to the point where I may never actually look at it, right? I've prepared it, I've gotten it down. The other thing you have to be careful about is to make sure you keep listening, right? And if you're looking down at your checklist and checking off, okay, I got that and I got that, you might not be listening to what the witness said. So you have to do both. You have to try to be dynamic and in the moment, but you also have to have the underlying sort of scaffolding there so you don't fall off.
Yeah. And I think that, if you're not listening, there's a good chance that the judge or jury is not listening. And so, I think that that's one of those when you're going through it in the chronological path, even though that may, makes somewhat of it makes sense from a logical perspective, you again can see when jurors are just getting lost and in just terms of the slow mumble of conversation that's going back and forth between the witness and the attorney. And I think sometimes when you hit those PowerPoints, at the beginning and at the end of cross-examination, you really like grab the jury's attention in terms of, oh man, this is a big issue, as opposed to it just kind of starting and ending where the DA ended it. So that's a huge point.
I remember when I was trying, I think it was maybe my 4th or 5th case, and I lost my first 6 jury trials. So all you lawyers out there just starting, you got to be trying them because you're going to lose them.
Got to have thick skin.
But I remember a bailiff telling me on a break, he's like, Chris, pay attention to when the jurors start leaning forward. That's what they really want to learn about, right?
Yeah.
And so I do that now. I pay attention. And, if they're leaning forward about a topic that I just can't puncture, then I'm probably going to stay away from it. But if there's some way I can, re-educate them or give them a different perspective, I might go straight to that, because I think it gives a signal to the jurors or the judge, if he or she's the decider, that I understand what they think is important and I'm going to get right to it. Right. So, but getting back, one other thing I want to tell you that, I love to tell this story to young lawyers, which is about a judge's input. In district court, I had lost like 5 or 6 straight, DWIs or assaults or so forth. And we ended up in the back with Judge Howerton. He liked to smoke against the rules. So, and on a break, and I was sort of grumbling, that's the 6th one I lost in a row. And he sort of upbraided me and he said, if you're not losing cases, you're not trying enough cases. He's like, you gotta keep trying them. You're going to get better, but also you're going to make the prosecutors know that you will try a case. And then, as you and I've learned, if they know you will try a case, they're more likely to give you a better plea offer.
For sure. And to kind of hammer that like same point home, I can't remember the name of the lawyer now that said this, but I was at a DWI CLE down in Georgia probably close to 10 years ago now. And one of the, seasoned lawyers that was presenting basically said, you're not a real DWI lawyer until you've lost 10 in a row. And that's kind of always stuck with me, because I think that is truly like the attitude that you have to have about it, is just, the cornerback, like, just you gotta have that quick forgetfulness of what happened on the last case.
Yeah, I'm a sports fan, so I use the cornerback thing, but I think some of the younger lawyers use Dory, the Disney character, the goldfish who keeps.
Oh yeah, that's right.
And so I heard some younger lawyers say, "Be Dory."
That's awesome. I've never heard that before. I love that.
Go back in there and do it again.
So, that's awesome.
Yeah.
Well, in terms of like you came out of law school and started practicing a lot in district court, and now primarily handling very serious. Again, I like the way that you put this last time in terms of what constitutes a serious charge. That was a cool thing that's kind of stuck with me. But in terms of handling higher level felony cases, what kind of led you down that path? How did you kind of get into that space?
Yes. So the story that I'll tell that story because is that I was going through about a serious case. I was going through the security line, right? And we see these bailiffs every day, right? And so one of them said, "Hey, Mr. Fialko, what you got going today?" And I said, "I just got this small thing up in district court." And he stopped me and he goes, "I bet you it's not small to your client."
Yeah, that was so powerful. I was really stuck with me since you said that.
Oh, you're right. It is not small to my client. We get, we see everything, the whole spectrum of charges, but to somebody who's just, been charged with assaulting their spouse, which is a misdemeanor and it's not a homicide, right? And but for them, it's like, this is the biggest thing. So I do try to keep them all in mind that everything is serious. So how I got to doing all the serious stuff, well, it was just sort of organic for the first 10 years. You start out doing lots of misdemeanor trials and lots of DWI trials. And DWI trials really, are where you learn how to try cases, because that and domestic violence are the cases that mostly go to trial. And then I got on the appointed lists and they started giving me felonies and I was doing those. And, I did several homicides, defenses. And then in 2003, so I've been practicing for 10 years, 11 years. I decided I wanted to try to do white collar work. And so sort of like I did with the 52-week program, but my plan was to go to the ABA white collar seminar, which only happens once a year, and just try to meet everybody that I could. There's like 3,000 lawyers that show up there every year. And so I would go up to people and talk to them and say, I'm Chris Fialko from Charlotte, and I've done a lot of blue collar stuff. I'm trying to get in white collar. And most of the reactions of these white collar lawyers were like, "Why should I send you for a freaking case if you're not doing white collar work?" And I sort of adapted quickly to say to them, my pitch sort of switched, which is, I want to do white collar work. I'm going to learn. I'm going to be good at it. But in the meantime, if anybody has any kind of case in North Carolina, here's my card. Call me or email me, and I'll figure, if I can't do it because it's, at the beach or somewhere, I'll figure out the lawyer to send you to. Well, oh my God, that worked, right?
For
so
sure. That's so awesome.
All these people in, Tacoma, Washington, or Albuquerque, New Mexico, they would be like, "Oh yeah, there's that guy. He's trying to do white collar, but he told me," so their cousin got a robbery charge down in North Carolina, and I'm going to call him. And so slowly but surely, like I did that work, or I got them referred to good lawyers, and then they started like, okay, well, this guy's certainly industrious, and they would sometimes send me the white collar stuff. So that's sort of how I broke into it, and been doing it ever since. Basically, I still go to the ABA white collar, and my goal is always to come home with 30 business cards from lawyers I haven't met.
I love the hard and fast goal numbers. The 52-week program, as you just referenced, the 30 cards. I mean, I do think that is really it's tangible, right? Like, I mean, it's so easy to go to an event and kind of having the mindset, I'm going to try to meet as many people as possible. But that's not tangible goal. There's nothing there to kind of hold on to. And obviously 30 conversations with people is a lot. I mean, over the course of a weekend,
I said it was a goal. I didn't know
yeah. No, right. I mean, but it's a realistic, realistic, even if high goal. But I love that. And I think that the cool thing about that in terms of relationship building is, you're putting yourself out there as the concierge of criminal defense for the state of North Carolina. That's huge. I mean, if you're making somebody else's kind of referral job easier, I mean, there's so many lawyers that, will refer cases that, it's like, who do I go to in this other state? You look them up on, some sort of lawyer directory, or maybe looks for some Google reviews. But if you have like this go-to person of like, look, I talked with this person, this is a great guy, great gal. They'll take care of you. They'll help you find somebody if they can't do it. That's such a powerful thing to put yourself out there as that. So that's something that, again, like, is really stuck with me, because I think that that's such a easy thing to do.
I mean, I sometimes will quiz younger lawyers, go on your phone, go to the bottom, how many contacts do you have, and ask them to guess how many I have. So I am at actually a round number this week, 4,500 exactly.
That's awesome.
And like 90% of these are lawyers that I've met, maybe 80%. But I also put every policeman and FBI agent, everybody in there. It's really, it helps me do well for my clients as well, right? So not only am I using this to get business, but like I will often call lawyers to brainstorm with them about cases. And one of the cool things about federal court is that the laws are the same across the country. So there are times where, I brainstorm with the good federal lawyers here, but then I'll be like, I'm going to call Lisa Mathewson up in Philadelphia, or I'm going to call Ross Garber in Hartford, because I know they may have had this particular federal issue before, or, I'm stuck on how to cross-examine this particular expert. And so this is just, invaluable to be able to call people up. And then, just like I've said before, I call them up and ask a favor to brainstorm, and that sort of increases their loyalty to me somehow. I don't know how that works.
No, I think that help attitude it's such an easier thing to pitch in terms of like networking. Cause when you're at like an event, you've never met somebody else before, it can feel like you're meeting a bunch of salespeople, like it's, here's what I do, here's where I practice. And it's just kind of going in one ear and out the other. But it's like, hey, if you ever have a client that has a problem in North Carolina, let me know, and I'll help get that person into the right hands. Now, again, you've offered like a free service as opposed to trying to sell something. And it's just such a huge benefit. So that is just such a cool viewpoint on it.
The other thing I learned to do is, like, if I'm going somewhere like one of these big seminars, I think about what's the question I'm going to ask everybody that I'm meeting. And usually it's this: I say to them after I introduce myself and we talk, I say, what's your favorite case you're working on right now? Like, and I can ask that to everybody, right? It's not specific. and they're like, most of the time, like, what do you mean by favorite? And I'm like, I refuse to define it. Just tell me what's your favorite.
That's awesome.
And so, but there are other times, like, when a particular type been a change in the law or something, I'll specifically say, do you have one of these cases? What are you doing about it? But I think it helps to sort of think ahead rather than just, it also gives you structure to have the guts to go up and be like, okay, I'm going to go talk to that person. And I know that the conversation won't suck because I'm going to ask them this.
Oh, yeah.
Talking, so.
I mean, you listening to attorney war stories is like some of the I mean, that's maybe
Right.
the best spent time. So, I mean, that's such a great question, because regardless of whether you ever talk to that person again in your life, you're going to get a great story. So
Right.
that's just fun. I love that. Hey, podcast listeners, I want to briefly interrupt today's episode to invite you to join me at the inaugural Freedom Fighter Summit in Asheville this October. This in-person only event is designed for growth-minded lawyers determined to take their criminal defense practice to the next level. Due to the size of the summit's venue, there are a limited number of seats available. Don't miss out on the incredible lineup of speakers and spectacular networking opportunity that this summit provides. For more details, visit www.mediclaw.com/summit. Enter the promo code NCDWI-GUY, all lowercase, all one word, at checkout for $150 off your summit ticket. Look forward to seeing you there. Now back to the show. In terms of kind of advice that you have for young lawyers that are, let's say getting ready to try their first case, their fifth case, what advice would you have? Obviously, we've talked about a lot of things over the conversation already, but what advice would you have for them in terms of that kind of first round of trials?
Well, it's going to be hard, and you're going to be nervous as hell, which is normal. So,
If you're not nervous, there's something wrong with you. But check your pulse. You might not be there.
Yeah.
So.
I try to tell them that, like, physiologically, your heart's going to be going, but that will pass. So I think that the more you prepare for a case, the easier it's going to be. And so I'm a big believer in trying to file some types of pretrial motions if you can, especially about evidence, like what evidence should be allowed and what shouldn't. Suppression, trying to keep out evidence that you think that was unconstitutionally obtained or so forth. What it does is it helps you sort of figure out and learn much more about the case if you do that first and draft those motions and be ready for it. And I think it can also educate the judge. So if you're in a jury trial, the judge is supposed to just be the referee, right? But the referee is important, and oftentimes the judges don't know anything about the case until the moment that the jury does, right? They learn along with the jury. But if you file pretrial motions, you get an opportunity to educate the judge early on. It also can help you with that nervousness some, Jake. If you get in there and you're fighting before the jury comes in, you can calm down a little bit on that. So
yeah, that's great advice.
Yeah, I think that you got to try to land on a theme. Well, let me go back. The other thing is field trips. Like, I love field trips.
Yeah, you were saying that. I love that.
I do it all the time. It's one thing that also Dave Rudolph really impressed upon me. I was doing it before I started practicing with him, but going on a field trip with Dave Rudolph was really dynamic. What I mean is, you go to the scene of the crime and you stand there and you look around, and you see what the surroundings were, and then you look back at the discovery and you look around and say, could they really have seen this from there? It just helps you imagine what has happened, and I think really can help you cross-examine people better. And I can tell you that jurors pretty much figure out, oh, Mr. Fialko's been to that scene.
Totally.
And that prosecutor has never been to that scene.
Totally.
So plus field trips can just be so much fun, right? And all the Law and Order TV shows, they don't show all the prep work that goes in and how, sitting in your office reading all the time. So go out on a field trip. It'll help everything on that. And then, you have to, these days, the thing that's changed is there's video in every case now, right? And you can have your staff sort of go through it first and index it for you, but you got to watch it yourself, even if you're not intending on putting it into evidence. You never know what you're going to find. So those are some of the main tips. I'll tell you the one story I tell people about field trips is that Dave and I went out to this gas station where the state star witness said that he had hatched the scheme with our client to commit the crime, which then they went and did like a few minutes later. And so we go to the gas station. There's cameras everywhere, like, and so we were able to take pictures of those and tell the jury, who in their right mind goes in there and hands a gun to this other guy? Like, this didn't happen. You know what I mean?
Yeah.
Because we were able to show, and then we were also able to cross-examine the police and say, did you ever go out and try to get video from that gas station
Yeah.
that your star witness told you? So there's lots of things from that. I would tell young lawyers that you're probably going to lose, but it doesn't mean you shouldn't fight like hell. And then we already talked about Dory or being a cornerback. During a trial, there's going to be a lot of times where you're going to wince because the evidence is bad for you, but you can still win. You can take 5 or 10 body blows and win because jurors are smart and they're patient. So don't give up during the trial. So those are some of the things that
I love it. Yeah, I love it. And especially the go visiting the site. I think that, on a DWI case, I've done that, countless times, and it's so powerful for a number of reasons. First of all, like, you have such a better picture in your mind of what was going on,
Right.
where field sobriety tests could have got done, what was, space, was there lights out there, is this on even pavement, whatever it might be, just to have a better understanding for cross-examination. But, it immediately gets the officer to turn into a yes man, because if you establish, like, I know, this distance, Officer Jones, didn't this happen, at the Kmart parking lot at this intersection, and there's a bunch of trees over on the, as soon as you establish that, that space, all of a sudden, you get that buy-in from the officer of like, okay, well, this person knows where this happened. I better be very careful about what I say. And, there's that, expert kind of buy-in, and definitely from the judge or specifically the jury's perspective, they recognize that it's like, even if you're not, even if it's not helpful, that it happened at this particular case, it's like, okay, well, this person's put in the, done the homework on this situation. I'll sometimes use like mileage of like, you followed him, it was about 0.25 miles, that, before it was turned, and then it was immediate stop, all of the details of that particular space. The jury is like, dang, that this is somebody that's really kind of put the effort in here. They're not just throwing this up for whatever reason or whatnot. I mean, it definitely gets that buy-in. I think it's such an important deal, and it doesn't happen that much. I really think the field trips are important.
Yeah. And you can do them in white collar cases too. I mean, like one time I went, my client was an employee at a very large company, and I went to see him in his office just because I was like, I got to do a field trip. And what I realized is his office was down like this way labyrinth of hallways, and then he was sort of at the dead end. And later on, one of the other employees said that he walked by my client's office every day to go to his office. I was like, fuck that. There's just no way you do that, and I was able to cross-examine him on it in a pretrial hearing. That case didn't go to trial, but so you never know.
Yeah, that's great.
The other thing that a public defender once told me about field trips is when you go on a field trip, make sure anybody who's walking by knows you're a lawyer. So I always go just like this with a tie on and my sleeves rolled up, carrying the yellow legal pad, because people will walk up to you and say, "What are you here for?" And I say, I was here for that robbery, that occurred last June. And they're like, "Oh yeah, my cousin was there." And then you're like, "Oh, really?" And then you find,
that's
so
awesome.
So make sure that you look like a lawyer when you go out to those times.
Yeah, that's fun. I mean, it's fun doing the field trips too. It feels like real legal work to some extent. It's like you're getting out there and seeing the space. It really puts you, I would say, much more invested in the case than you otherwise would be.
Yeah. The other thing about advice for young lawyers, this may be more just like a morale boosting, is because sometimes you can, if you're trying a bunch of cases in misdemeanor district court just in front of a judge, you can be like, what good am I doing at the moment, right? I keep losing and so forth. But every trial educates the judge, right? Every trial educates the prosecutor and also the police. I think we talked about this before. I mean, you and I both had the experience where policemen have told us afterwards, yeah, you know what? Next time you got me on that issue. Next time I'm going to do better, right?
Yep.
You've had
Yep.
experience, right? So every trial is like a mini civics lesson. And so try cases.
Yeah, for sure. I mean, I think to that point, and you had mentioned this, in our original conversation, is this is the opportunity for judges to assess law enforcement credibility,
Right.
to see how prosecutors are kind of conducting themselves, obviously the defense bar as well. But one of the attorneys at our office recently had a case. Judge granted a preliminary indication, based on poor investigation of law enforcement and just they honestly badly trained. It was just not a good case. State appealed it, went up on appeal. Evidence came out very different in terms of the de novo hearing in Superior Court. So probable cause motion was overturned. It went back down to district, and the attorney and I were talking about it from my office, Amy, and it was kind of like, she was like, well, the numbers coming into evidence, what I think I should do. And I was like, you should try it and point out like all of this that got changed. And so she did. And, the judge ultimately, and this is kind of where I thought he would go, ultimately convicted our client, but sat there for a long time in deliberation. And then basically, said in open court, you get one chance, to destroy your credibility, if that's what you want to do. And that's what you've done in this situation. And so, I mean, I think that is part of the value that you're bringing. And, her client was through the roof about this, her kind of calling this, kind of process out. So, obviously wasn't happy with the result, but in terms of her representation, wrote like a glowing review of like, hey, this attorney really went to bat for me, like, upheld the judicial process and made sure that, officers' feet were held to the fire on this after kind of what happened. So, I mean, it's important, even if you're on the losing end of things.
Yeah, it definitely is. And as our North Carolina system works, the judges who start in district court often end up on Superior Court doing jury trials, and the policemen who start off doing patrol often end up being the homicide detectives. And so, there's a learning curve through every trial by everybody, right? And so you can go through. I've had experiences where a Superior Court judge is now trying to decide an evidentiary issue about whether to believe this detective, and they've had many trials with him before in district court, and that helps inform the decision. So yeah, I mean, it's a more longer term thing. Look,
yes,
one of the corny things about our job, I'm in a nice building, but the lights turn off when you stay still. Is that one of the corny things about our job? But it's true, is we're trying to keep us from having a police state, right?
Yes.
And we're trying to keep. I think that 95% of police officers are hardworking and honest, but we got to make sure that they stay that way, and that's part of our long-term job. Our short-term job is, zealously advocate as hard as we can for the client we have today. But in the long term, like my catchphrase on my website is, I'm defending the Constitution one client at a time, right? And so in the long term, I think we do serve to keep us from being a police state.
Totally. Yeah, totally agree. Totally agree with that. Well, Chris, I know you got to jump here in just a couple of minutes. So last question on your end. If you could go back, 3 decades back and talk to young Chris Fialko before having his first case in the courtroom, what advice would you give yourself back then?
Yeah, I hate this question. Because what you initially want to say is, learn this more quickly or learn that more quickly. But I've sort of valued learning things the hard way over the
Yes.
years,
Yeah.
right? It just gets more ingrained that way. But I think number one is, if you have a triable case in district court, just try it. I mean, and I think that even if you lose, the judge is going to have a lot more information and may give a more just sentence. Couple other things that I tell people is just try to hone your confidence. Like, tell yourself, be more confident in the courtroom. And that may mean, putting aside your outline and cross-examining somebody like in the moment. There comes a time where you have to sort of lose your self-awareness in the courtroom, and they're looking at me. They're looking,
Yes.
just go ahead and do it, and everything becomes more natural. I'll tell you the one thing that I would have told myself, which is really what your question is, was to lose my temper more often.
That's awesome.
My temperament was such that I really don't lose my temper. And so I had to start writing in like notes, or like in the cross-examination, I would literally write, lose your temper here, right? Because
that's awesome.
And so, sort of identify your weaknesses. I learned it was a weakness that I didn't get mad at certain points. And part of it is just to show the jury, like, something screwy is happening right
Yes.
now. So
I think that's just like letting your personality come out.
Right.
Everybody's got their own persona in the courtroom. And I think we, a lot of times go away from that in terms of, here's how I should appear in court. And
Right.
Obviously you don't want to, get held in contempt or whatnot. But at the same time, I think, finding your courtroom persona is a really big deal, because that's where you can really have fun with it.
Yeah, you can. I guess the last thing is that I wish I would have learned this sooner. Is sort of do a field trip in the courtroom. And what I mean by that is go sit, like, before, if you're trying a case, go sit in the juror's seat. You can do that. You get there early before they're there, go sit in their seat and look around and see their perspective. Or, like, now I'm going to lots of different courtrooms around the state, and the witness box is in different place, right? So I'll go sit in the witness box to see, can they see me where I am, so just, sort of, walk around the courtroom a little bit and try to get the perspective of other people, is a thing. And you'll feel more comfortable that way too. I try to get to a courthouse early and sort of walk around. And so those are some of the things I'd advise you to do. But the last thing is, I guess, just remember to have some fun when you can, right? Or recognize when a good or fun moment happens. Dave Rudolph and I used to have a contest to see who could get, when we tried cases together, who could get a witness to say the word fuck on the witness stand. And these were cases that were taken, long trials, week to week, in one case, one trial. So, that you have to sort of add some sort of fun to this job, because, look, a lot of the time there's tragedies that have happened and they're the subject of it, right? And you can just get ground down by it. So you've got to try to keep your spirits up somehow. So
I love all that. I think, again, in terms of your point to, being kind of a tough question and, really valuing all the mistakes, I feel like I've learned so many lessons, in terms of courtroom lessons, business lessons that happen because I really made a mistake, sometimes small, sometimes big. And those lessons stood with me a lot longer than if I read about it in a book or, got kind of, talked to an attorney and they said, hey, you should do this thing. When you make the mistake yourself, it's a much better stomping ground. So just that mindset of mistakes are going to happen and that's okay, and put yourself out there. I really love that. So, well, Chris, I know you got to jump. I really appreciate you doing this with me again.
Sure.
It's been just as fun this time as it was the first time. So thank you very much.
Well, I enjoyed it, and I appreciate your podcast. I've watched a number of episodes, and again, I always learn something from one of the lawyers or people you talk to. So keep it up.
Thank you very much, Chris. Appreciate it.